Alrighty, here's part two of the subject matter jurisdiction challenge. This we the people news, not attorney, not giving legal advice. Okay, educational purposes only. Always look straight forward. Never. Let me go flip that one back. What do you think? Never look straight forward. Always look around you to be able to protect yourself by any means necessary. Use the Second Amendment of arming yourself with knowledge. Okay. Um, so I guess my storage space is a little short, so if it cuts off early in the process, that's why. Like it just happened, okay? So this is part two, and these are case laws that people tend to go by, so judges don't have to think on their own, and actually, they had to research cases 100 years ago instead of actually learning how to think on their own. All right, let's go.
Will be a moot discussion, but that's what I'm going to tell that guy is we can appeal that decision. But let's wait until we get it in writing. They haven't even given us anything. This is all hearsay at this point. You see what I'm saying? So, anyways, let's keep going. A departure by a court from those recognized and established requirements of law, however close apparent adherence to mere form in the methods of procedure which has the effect of depriving one of a constitutional right is an excess of jurisdiction. You need to understand.
Sit and think about that. How many times have you heard courts say, this is not a court of the Constitution? Well, they just denied you due process of your constitutional rights.
And when they're denying due process, okay? And when the judge, when you ask a question and the judge answers it instead of the prosecutor, the judge is working for the prosecutor. That's a denial of due process by definition. Okay, the judge has got nothing to say. He's supposed to be sitting there playing stupid at worst, and at best he should be honoring his oath and protecting your rights. But they're not interested in that. They're nothing but a bunch of bought and paid for whores. Don't get me going. You're going to get me going.
Now, on a side note on that, right? Are they legislation from the bench, or are they giving legal advice, or are they practice being your attorney, right? Are they saying that they're attorney and they're making a claim that they have subject matter jurisdiction instead of the prosecutor? Are they or are they not giving legal advice?
Shifts to the court to prove jurisdiction. A court has no jurisdiction to determine its own jurisdiction. For a basic issue in any case before a tribunal is its power to act, and a court must have the authority to decide that question in the first instance. So they don't have authority to say, oh, we got jurisdiction. Bull. A court cannot confer jurisdiction where none existed, and cannot make a void proceeding valid. It is clear and well-established law that a void order can be challenged in any court. It's collateral. You can go after them collaterally, which means you can file a separate lawsuit. You can do anything you want. It's a nullity. Thus, where a judicial tribunal has no jurisdiction of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. It didn't exist. It is nothing. Ab initio. Right. Judge loses his absolute immunity from damage actions only when he acts in clear absence of all jurisdiction or performance of an act which is not judicial in nature. Okay, so we're coming after you, Judge. Are you ready for that? Of course, you're going to have to get his bar member buddies to go along with it, and that's what he's banking on. There is no discretion to it.
And that's the reason why on Kirk, it keeps on having all these judges thrown to the side, right? Because he's got lawsuits against the judges. Why? because they never had such jurisdiction.
Nor that lack of jurisdiction. The law requires proof of jurisdiction to appear on the record of the administrative agency and all.
I'm going to pause right there. So the bottom one is KETCHAM 52F 2D 948. If it's hard for me to see it on my TV, then it's hard for you to see it on this.
Administrative proceedings. Nelson was saying that in the New Jersey Constitution it says it's all administrative. Well, they still got to prove jurisdiction. Any way you want to look at it. Where there's no jurisdiction, there is no judge. And that's what you say, basically, or what I would say, is so you want to be a bought and paid for clerk masquerading as a judge. Is that correct? Turn it into a question. He can't find you in contempt for asking questions. Anyways, where there's no judge, there's no jurisdiction, there's no judge. The proceeding is as nothing. Such has been the law from the days of Marshall Say. Now that's a cite. That's a federal court. This Manning versus Ketchum is a federal court, but they're citing the U.S. Supreme Court in Bradley versus Fisher. That's a U.S. Supreme Court citation, and they are citing 10 Coke 68. That is Lord Coke in the writings. I think it's called the Commentaries on Littleton, which goes back to the 1500s. This is as old as time itself. If they don't have jurisdiction, they're nothing but a bunch of thieves and pirates.
And hence is the one deal as well, right? How can they have jurisdiction if the claimant never steps forward, right? The city of Houston, 6th Amendment, right? I have a right to face my accusers. I need to see the, Mr. and Mrs. Houston step forward. They're the claimant, right? But they got to play this corporate body where the CEO is hiding in the back and saying, oh, I don't know nothing. And this is what our judicial branches look like today. Protect the corporation and hide. Which goes back into what? The 48 laws of my previous couple videos.
And it's up to you to know that's what's going on. That's why I don't go into those so-called courts. And that's why I just file criminal complaints against them. In arriving at our decision in this matter, we do not depart in any way from our holding in Homeling versus Jensen that the doctrine of judicial immunity extends to courts of limited jurisdiction. But when a minor magistrate acts wholly without jurisdiction, civil liability attaches for his malicious and corrupt abuse of process and his willful and malicious oppression of any person under the pretense of acting in his official capacity.
That case right there, right? It is heavy. Heavy. I'm just saying, put that in there with the magistrate, which, by the way, everything starts off with the magistrate. Everything. Okay? You walk in there, they call them judges, but it's a magistrate. Because what they're doing is seeing if there's jurisdiction in the issue and the standing in hand to proceed to the next level to see a judge. Of course, in Texas, everybody's a magistrate, but there is a vague difference where you can still call it out because I have a right to a judicial branch of a real judge to get remedy that the harm, loss, and damages has been brought upon I.
It's malicious is what it is. That's exactly what it is. If they don't have probable cause, it's a malicious prosecution. Lack of jurisdiction equals a void judgment. Proceeding without jurisdiction is a malicious prosecution. So we're doing a malicious prosecution, are we here? See the void judgments video. If you tell you they have jurisdiction without proving jurisdiction, it's a war crime. So we're doing war crimes here today, are we? And this under the Libra Code. Okay, so we go into that. And some of this stuff is slides from other presentations that were done about it. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law, the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Texas is under a military occupation. I believe that everywhere in America is under a military occupation, but the question is how do you prove it? I can prove it in Texas for sure, any of the southern states. Martial law is the immediate and direct effect and consequence of occupation or consequence of the presence of the hostile army proclaims its martial law. Martial.
Okay. And we're going to not go any further with that one, unless you guys want me to later on in the future. But challenge jurisdiction. All the attorneys keep saying sovereign citizens, sovereign citizens. But there's cases you can look up saying anybody can look at. The question is, why is it your attorney challenging jurisdiction? That is the true question, people. Why aren't they not challenging it? We have to learn the law because we cannot trust attorneys to do this in a correct standing. Just saying, right? And on the martial law thing, I have not found any evidence that Civil War has ever ended. Some people argue that, don't care. I have not found any evidence that there's been the Civil War is actually ended with Congress. Okay? So therefore, if it's never ended, then martial law is still in effect today. And if there's war on crime, that's a war. Martial law, war. Till next time, this will be the People News. Bye, y'all.